only is this sort of a set of facts, but also a set of laws, if you will, that are uniquely suited for the criminal law classroom. It gives us a revealing look at three of the hardest doctrines, I think. Everyone studies homicide if they take criminal law. We spend probably a quarter to a third of the entire class on it. And these are some of the hardest doctrines to get down for a student, because they all share the three charges that Derek Chauvin was convicted of, all share the quality of being unintended killings, right? Going back to the Bible, we have a rather clear kind of bifurcation of killing in our sort of moral vision. There's intentional killing, which the Bible describes as virtually lying in wait for somebody you hate, to purely accidental killing, where you're in the forest chopping wood with your friend and the axe handle falls off, by accident and takes them out. But all of these fall in between them. The most serious charge he was convicted of is felony murder, which is second-degree murder in Minnesota. And felony murder is often one of the most criticized doctrines in your professor's treatment of criminal law, because it allows the prosecution to convict somebody of murder without showing that they had a culpable, really guilty mind, as it were, with respect to the victim's death. Instead, the prosecution merely needs to show that they were intending to commit another felony, like robbery. In this case, it was the felony of assault. And sometimes this doctrine is used to really convict people who seem very remote from the moral wrong of a crime, like an accomplice that goes along with their friend to do a burglary and has no idea that their friend has got a weapon that they're going to use on the homeowner, for instance. And they can be convicted of murder under this kind of a doctrine. Here's a case where I think you can kind of understand why there's some congruence between felony murder and a moral intuition, at least some cases, because here, as the very vivid nature of the video shows us, an attack on George Floyd, the felony of assault, that even though Officer Chauvin at the time wasn't intending to kill, he was intending to harm this person in a very serious way for purposes of satisfying essentially a criminal desire, not justified by anything. And while we may quibble over whether that's exactly the moral equivalence of intending to kill somebody, it's certainly not a completely haphazard way of holding somebody liable. The second murder doctrine he was convicted under is even murkier and harder to wrap your mind around. And that's the third-degree murder in Minnesota. It's often called in the common law terms abandoned and malignant heart murder, which sounds like either a country western song or a horrible diagnosis that you don't want to get. But it actually refers to a killing that takes place in a context or through a method that reflects such sort of gross disregard for the humanity of people around you that it shows essentially a complete indifference to human life, similar to what is expressed by intending to kill somebody. That's at least the moral theory behind it. And again, it's hard to figure out when is an unintended killing so bad in its motives, although you didn't intend to kill, or its context, that it warrants this. Historically, it's involved things that have endangered multiple people, like throwing a beam off of a construction site onto a crowded sidewalk, knowing that many people would be injured potentially, or even killed, or firing a weapon into a crowded room, without aiming in particular. But here, there was just one individual, and yet you can see, in a sense, exactly what might be meant by that notion of abandoned and malignant heart. And while that's not the actual language used in the Minnesota statute, wasn't it interesting that the prosecutor, maybe thinking of Dr. Seuss, said in his closing argument that George Floyd died because Derek Chauvin's heart was too small. The final level of culpability here in the final conviction was for manslaughter. And that's essentially when you cause the death of another person not intending to, but with a carelessness, where the death was caused by conduct that departed so far from the standard of care, that it goes beyond mere civil liability, but really expresses criminal culpability. And that's why Minnesota calls it culpable negligence. So it's supposed to be more than just, what you might sue your neighbor over, even if you're seriously injured by accident. It expresses, if not indifference to human life, at least a gross negligence that reflects on you a culpable departure from what your neighbors, should be able to expect. Here, it's interesting because often police officers have the advantage when we think about whether their force is reasonable, that the law treats them as experts, as professionals, that it's only from their perspective that we should assess whether they saw themselves as threatened. So we essentially treat them as the best witnesses to their own judgments. Here you see how that can come back to bite, in effect, for a defendant who's a police officer, because having decided that his force wasn't reasonable, and having had many police officers for the prosecution testify to that, I don't think it was hard for the jury to ask themselves, well, was it unreasonable enough? Because the very fact that he was a police officer with all that training and with all that experience now meant that he really, if he didn't see that this was endangering Floyd's life, with Floyd begging for air, etc., then he surely departed from what a reasonable standard of care was enough to be culpable. I'm going to have to give the classic professor wiggle on this and say it will and it won't be, right? It will be, because we've had an extended period in which police officers were almost never charged with criminal homicide, and murder was almost always off the table. In the Freddie Gray case in Baltimore, the prosecutor tried it and they were acquitted on all the charges. So I think that this is a signal, especially to prosecutors, that these cases are viable, that juries now are, if they're properly presented evidence, can convict police officers, that they're not so biased in favor of the police. The problem is twofold here. I think one is that there are going to be so many cases where the clarity is far from that represented by the evidence surrounding George Floyd's murder. And indeed, many cases where either there's no video at all, or it's completely in that, on the officers' body cams, and may or may not be turned on, may or may not be captured. And even the basic question of whether other police officers are going to now take more seriously their duty to step in and prevent something like this from happening again leaves me worried that unless there are really cameras around that can objectively capture what they did, the threat that comes from betraying the what has been called the blue wall of silence is so great that it's not a cowardly act. It would take a brave person to do the right thing in those situations. The other thing I think we should acknowledge here is sort of the limits of accountability as a model, at least if it turns on waiting for the worst things to happen, waiting for actual deaths to happen. Because as a number of activists and some legal academics like Devin Carbato at UCLA have pointed out for a while, behind each of these lethal acts involving in many cases, Black people, and especially Black men in our urban areas, there are hundreds, thousands really, of police stops, unnecessary police stops done on a pretext. If we look at the case of Daunte Wright, who was killed by a police officer 10 miles from where the Derek Chauvin trial was going on, right? So you imagine, like, if deterrence is going to work, it's going to work when they know that the man's on trial for murder. And while obviously not in anticipating that they were going to kill the Daunte Wright, they chose to, based on the color of his skin and his location, to impose a police contact on him, designed either to train the officers in how to humiliate people, or on the odd hope that they would find drugs or other things of criminal nature that aren't necessarily what we prioritize in terms of public safety in this country, and yet put at risk lives and are certain to have degraded people and humiliated them, often in front of their neighbors and children. So that kind of aggressive and really anti-Black policing that has been called out by the George Floyd murder and by the social movement that's arisen. It's important for people to understand that the conviction of Derek Chauvin will not change those practices, won't even deter those practices, because you have to really get to the earlier stage. You've got to take away the power of police to impose their discretion on people, and especially people of color, if you're going to, really do something about this. And that won't be so much accountability as changing the regulations and taking the power of police to stop cars away unless they have, a real reason to believe that you're a danger to traffic, or they know that you've committed a crime, and then they should arrest you.